You don't have any specific rights to custody or visitation, and neither does the mother. So it's important that you get a petition filed and you get a case started so that you can be in your child's life as you would like to be. What's going on, guys? My name's Mark Reel Jr., the Father's Rights Attorney, and you are watching lesson number 3 of our masterclass on child custody in the state of California. Now, in lessons 1 and 2, we covered some of the basics. We covered the 30,000-foot view of what you need to do to get custody orders in the state of California. We covered the timelines and we covered the process. Now in lesson number 3, we're really going to dive in and we're going to get a little bit deeper about what it really takes. So the first question is, how do you start a child custody action? So in the state of California, we call this a parentage action. So when you are going to the court asking for child custody orders and you are not married to your co-parent. So the first thing we need to do is we need to file a petition. A petition is how you're going to open your case up, how you're going to start your case. In California, we have what we call our judicial counsel forms, and to start a petition, you need to fill out the FL200. That is the petition for parentage action. And in this petition, it's a 2-page form, and you're able to follow through the numbers. You're going to give the information about yourself, the information about your co-parent, and the information about what you are looking for in terms of child custody. Once you fill this out in a petition, you're going to have the FL200, that's the petition, and there's going to be 2 other forms that you're going to need to fill out. It's going to be the FL210, which is the summons. You're going to provide a little bit of information about yourself and the contact information for your co-parent. And lastly, the FL105, which deals with jurisdiction. Does the court have jurisdiction over your child? Because in a child custody matter, the parents are somewhat irrelevant in terms of what state and what courthouse can handle a case. It's going to be about where the child or children lived or are currently living. So this is what it's going to take to get your case started. Now, it's important to know one of the most common questions we get is, as a father, do I have any rights before I go to court? The answer is it depends. In the state of California, if you are on the birth certificate, if you sign the voluntary declaration of paternity at the hospital, you have the same exact rights as the mother. But you don't have any specific rights to custody or visitation, and neither does the mother. So it's important, if you are in a situation where there's uncertainty, you aren't getting the time with your child that you need, that you get a petition filed and you get a case started so that you can be in your child's life as you would like to be. All right, and now on to the second part of what I'll call stage 1 of any parentage action here in the state of California. So one parent has filed a petition, they have served the other party. Now the party that's been served, whether it's the mother or father, must respond. Now, the first step, if the other party has filed, is you'll be served. Once you're served, you have 30 days to respond. So you are on a time crunch. This is something where there is a deadline you need to get it done. So if you've been served by your co-parent, you have now 30-day time shot clock for you to get your response filed. Now, the response, which the judicial counsel form, is the FL220. It's a 2-page document that's going to ask you the same exact information that the FL200 asks for the petitioner. It's going to ask you about the petitioner's information, your child's information, and most importantly, it's going to ask you what you're looking for in terms of child custody. So once you have the FL220, which is the first document you're going to have filed, the only other document you're going to be required to file is going to be the FL105, which is that jurisdictional document about where your child or children have lived over the past 5 years, where they currently live, who they reside with, so that the court can take jurisdiction of your case and make orders. Now, the petition response, this is not how you're going to get a court date. This is how you're going to start a case. And as we move into the next lesson, we'll cover, once your case is started, how do you get into court to get those initial court orders? So we'll see you guys in the next lesson.